Norman, can you share with us a little about your victory in the past week and how it relates to Daniel's case?
Sure. I represent Nick Spray Reagan, Tuck It Away. It's a moving storage van in a company in West Harlem. Columbia wants to have 125th to 133rd, Broadway 12th. It's about 17 acres. And over the last 8 years or so, it's used eminent domain as a gun to people's head and has purchased 61 of the 67 buildings in that area. The Spray Reagan family owns 4 of those buildings, and the Singhs own 2 gas stations. And the Spray Reagans and the Singhs are opposed to eminent domain and are fighting that. And last week, a week from today, the appellate division, 3-2, said that eminent domain cannot be used in the West Harlem Columbia expansion plan. I've cautioned everybody, including my clients, that if you want, have a drink one night, but we still got a huge challenge before us. It'll go to the New York Court of Appeals. Bob is absolutely right. With regard to New York, I've read at least 50 years of New York court decisions with regard to the enormous deference that they give to administrative agencies like the Empire State Development Corporation, especially on the issue of eminent domain. Over and over again, for some reason, well, not for some reason, but a specific reason, because it deals with money and property, the courts don't get involved. They don't intervene. And what was remarkable about last week is that the record that we put together, the court decided to at least say something about not only the substantive aspect of eminent domain, but the procedural aspect of eminent domain. For example, as far as I know, and I've asked Bob to double check me so that I'm not saying things incorrectly in the future, as far as I know, New York State is the only state in this country where when you challenge eminent domain, you go to the appellate court. If one of you asked me tonight to go in and sue some government agency, and I said, yeah, and I stayed up all night, and sometimes I do, and went into court tomorrow, I go to the trial court. And in a trial court, you get a chance to get discovery, you get a chance to cross-examine your opponents. They're under oath, you take depositions, you put them on the stand, and maybe you move to finding out what the truth is. But in eminent domain in the mid-70s, our state legislature changed that process. Up to that point, in New York, you go to the trial court. But they changed the process because they thought it was delaying development. You got to remember, as Bob was talking, and Christina was talking about, the Institute has been so good on this issue for so long, that there's this connection between the developers and the politicians. The developers give the politicians money, and the politicians, in their quid pro quo in return, make sure that the laws grease the process for the developers to do what they do, and to make sure that they can make the money that they do make, even if it's at the expense of people like Dan Goldstein, the Spray Reagans, the Singhs, etc. So the idea that you can't go to the trial court is a huge fundamental due process problem. And you go to the appellate court and you're given 15 minutes to make the argument. None of the speakers up here tonight, including myself, will be able even to stay within 15 minutes in this program in talking about this issue. So the difficulty of being able to synthesize and condense and say it within 15 minutes. The whole process is sui generis. The whole process is by design, and it's by design to make sure that the developers can get the eminent domain. And then, of course, the developers say over and over again, I don't have the power to exercise eminent domain. It's the government who's doing it. But the government wouldn't be doing it but for the developers trying to get the government to do it. And I've always told communities, check all your politicians, check where they get their contributions from. I ran for the Office of Public Advocate, but I have to say, as far as I know, I never got $1 from a single developer. And I always thought that that was significant. It wasn't that I, as some politicians do, say, I don't want your money. I was desperately seeking developer money, and I never got a penny. So I think that says something in and of itself. But also, the last thing I want to say about the win. I say this, when I'm in the courtroom, I'm a mouthpiece. That's what lawyers are. And the legal part has to be connected to the community part. When I'm in the courtroom, my passion, my discipline, my anger is because I've been in all those community meetings, whether it's in Prospect Heights, West Harlem, or Wills Point, and you hear the voices of real people and how they're hurting because of eminent domain. And they're hurting because of what Mindy was saying, which she's written about so eloquently over the years. And you get up, and it's your opportunity to persuade judges. I'm like Michael. I still believe. I still have faith. I still believe that the system can work. It's not easy, but it can work. And you need that movement, that coalition of the people in the community, the real people, together with the lawyers, with the business people, with the organizers, with the spokespeople, the PR people, in order to even have a chance at winning on these fights. And on our win at this point, we have to caution people not to get too excited, because we still have a huge challenge ahead of us in the New York Court of Appeals, and then potentially come down to your neck of the woods, the US Supreme Court, to give them a chance to undo what they did wrongly in Kelo versus New London. So the fight continues, and I do think that there is a growing movement, not just in New York, but all across this country. The catalyst is the Institute for Justice, to bring the kind of coalition together to say enough, that we do have to have reform. And I do think in New York, in due time, despite the people in power at this point, that we will see some reform within the next few years.